All right, let's talk about what happens when happy hour goes head-to-head with a homeowners association. We're diving into a story out of a quiet retirement community, Sun City, Oro Valley, where a pretty simple plan to serve wine at the coffee bar, well, it completely spiraled into a full-blown legal battle. I mean, you have to wonder, right? How on earth does something so small get so out of hand? That's the big question we're digging into. And we're going to use the actual court documents to piece together what really happened. So, on one side, you've got John Balaco. He's a resident who's basically saying, hey, you're not following your own rules. And on the other side, you have the HOA board. They're just thinking, hey, this is a nice little upgrade for everybody. It's the classic story, right? One resident against the entire board. All right, so let's really get into the weeds here, starting with Mr. Balaco's side of things. You see, for him, this whole fight, it wasn't really about the wine at all. It was about the rules. Believe it or not, this entire legal battle comes down to this one sentence, this single clause from the community's own rules. And you're going to want to remember these three words: substantial change in use. Because really, the whole argument is about what those words actually mean. So here's Balaco's whole argument in a nutshell. He's saying, look, getting a liquor license isn't just like, adding iced tea to the menu. He sees it as a fundamental, a substantial change. Suddenly, you've got all these new state regulations to worry about in a shared space. It might even change who can use the area and when. And because of that, he says it needed that special 60% vote. Okay, so that's one side. But the association? Well, they had a completely different take. As far as they were concerned, they'd done everything by the book. And hey, the people had already spoken. And the core of their defense really comes down to this one single number, 1,121.
What is that? Well, that's the number of residents who voted yes for the big renovation project. A project that, by the way, clearly mentioned the new coffee and wine bar. So with a 65% approval rate, the HOA was like, we're good to go. The community already gave us the green light. And to back that up, they pointed to all the work they did to keep everyone in the loop. I mean, look at this. They held 3 different community forums. They put a presentation online that was viewed almost 1,000 times. They were sending out weekly emails. So from their point of view, they had really done their due diligence.
Okay, so now things get serious. It's time for the formal hearing, where everyone has to make their case under oath. And just to add a little modern twist, this all happened over a remote call.
And you know how it goes. If you've been on a video call in the last few years, you'll probably relate to this. Technology did not want to cooperate. This quote just gives you a little taste of the real-world chaos of it all. Fuzzy audio and all. So, during the questioning, Mr. Balaco really honed in on one specific point. He asks the HOA manager, hey, in all that information you sent out, did it ever specifically say you were applying for a brand new liquor license? And the answer was no. Which, of course, was a big point for Balaco's argument that people didn't know the full story. And here's how the general manager for the HOA saw it. His argument was basically, look, this isn't a substantial change. He pointed out that they already had a coffee bar, and the building even had a liquor license years ago. So just moving things around a bit and adding wine, to him, that was a minor tweak, not some massive overhaul.
So there you have it, 2 totally different ways of looking at the exact same rule. What one guy calls a substantial change, the HOA calls a simple upgrade. After hearing all of this, the judge was finally ready to rule.
And the decision came down. Petition denied.
Just like that, the HOA won.
But wait, here's where the story takes a crazy turn. The reason why the judge denied it? It had almost nothing to do with whether the change was substantial or if the vote was fair. The whole case got tossed out on a legal point that nobody was really even arguing about. It all came down to this legal idea called the ripeness doctrine, and it's actually pretty simple. It just means that courts don't deal in what-ifs. For a case to be ripe, as in ready for a judge to hear it, somebody has to have been actually harmed. You can't sue over something that just might happen in the future. And that's exactly what the judge said. Since they hadn't even started building the wine bar yet, there was no actual harm. No one's access had been restricted. The whole thing was just a theory at this point. So the judge basically said, you're too early. There's no problem for me to solve. At least, not yet.
Okay, so this one little fight in an Arizona retirement community is over. But what does it mean for the rest of us? What can we learn from this whole thing?
Well, there are a few big takeaways here. First, timing is absolutely everything. In the eyes of the law, a potential problem isn't a real problem.
Second, words really, really matter. This whole mess was about one word, substantial. Third, keeping good records is your best defense. The HOA's paper trail of meetings and emails was a huge part of their case. And maybe the most important one, know the rules. Seriously, reading those documents before there's a problem can save you a world of trouble. And that kind of leaves us with one last question for you. Do you actually know the rules where you live? Could you, right now, draw the line between a minor change and one that's substantial? It's definitely something to think about.